I want you to picture a scene. It's late May 2019. You're in Brooklyn, New York. It's a warm day, traffic is heavy, and you are riding your bicycle down 14th Avenue.
Classic city scene.
Totally. It's that squeeze car, it's parked on the right, moving traffic on your left. You see a livery cab stopped up ahead, and you decide to, thread the needle. You go for that gap, and then wham!
The door opens.
The rear passenger door just flies open. You get doored, you hit the pavement, and you hit it hard.
It's every cyclist's nightmare. And usually when we see legal files about this kind of thing, the entire debate is about liability. Did the passenger look? Was the cyclist going too fast?
Whose fault was it?
Sure.
Exactly. And when I first looked at the stack of documents, that's what I expected, a standard personal injury lawsuit. But, and this is where we have to pivot, immediately, this deep dive isn't really about the bike crash.
No.
I mean, the crash happened. Laura Moldovin, the cyclist, she was injured. But the real story, the one that makes this case so mind-bending, it all starts the moment the ambulance pulls away.
That's right. What we're actually looking at is a legal letter motion. It was filed in federal court here in New York. The case is Moldovin versus Singh and Lyft, Inc.
Right.
And the document comes from the defense attorneys. They're not writing to the judge to complain about the accident. They're asking for permission to expose what they call a far-reaching scheme.
When lawyers start throwing around words like scheme and fraud, my ears just perk up. The defense is alleging that the plaintiff's surgeon, a Dr. Sebastian Lattuga, isn't just treating a patient.
No, they claim he's running a whole financial operation.
An operation that involves revoking insurance contracts, charging these massive markups, and get this, charging his own patients interest on their medical bills.
It is a fascinating, really complex machine. Our mission today is to take this whole thing apart, gear by gear. We have to follow the money to understand how a standard no-fault insurance case allegedly mutates into this situation where a surgery that should cost $3,000 ends up billed at $45,000.
$45,000. That is a massive number. Okay, let's unpack this. We have to start with the medical side to get our bearings. So Laura Moldovin gets doored. She goes to NYU Lingo and gets treated, and she's released. But the story doesn't end there.
No. Typically in these cases, if the pain persists, a patient will seek out a specialist. Moldovin ends up at a practice called New York Spine Specialist.
Okay.
And it's really important to note this practice is owned solely by Dr. Sebastian Lattuga.
And about 5 months after the accident, November 5th, 2019 to be exact, she goes in for surgery. It's called a one-level fusion at the L4, L5 vertebrae. For those of us who aren't spine surgeons, what exactly is that?
It's a major procedure. You are effectively welding two of her vertebrae together to stop them from moving.
Wow.
Yeah, the idea is to stop painful motion, but it involves hardware, screws, rods. It's invasive. And this is where the defense raises their first huge red flag. They brought in their own expert, a Dr. Paul Kuflick, to review the MRIs.
And I'm guessing Dr. Kuflick didn't quite see what Dr. Lattuga saw.
Not even close. Dr. Kuflick's report was incredibly blunt. He reviewed the films and concluded there was, and I'm quoting here, no indication of an acute injury.
No acute injury.
He said the pathology that was present did not warrant surgical intervention.
So we have a classic he said, she said on whether the surgery was even necessary. But in personal injury law, isn't that pretty standard? The plaintiff's doctor says, I'm broken. The defense's doctor says, you're fine.
It is standard. If this were just a difference of medical opinion, then we wouldn't even be talking about it. Doctors disagree all the time. But the defense's argument here goes way beyond that. They're arguing the surgery wasn't just a bad medical call.
What are they saying then?
They're arguing it was a necessary component of a financial engine. They claim the surgery had to happen to unlock the money.
Okay, to understand that engine, we have to talk about no-fault insurance. New York is a no-fault state. The idea is that your own insurance pays your medical bills no matter who caused the crash.
Right. Precisely. It's a trade-off. It's designed to get doctors paid quickly, so they don't have to wait years for a lawsuit to settle. But in exchange for that quick, guaranteed payment, doctors have to accept a set rate.
A fee schedule.
Exactly. You can't just charge whatever you want. You charge what the state says that procedure is worth.
Okay, so keep that in mind. Guaranteed money, but the prices are capped. Now let's look at the timeline the defense lays out. This is where the plot really thickens. In September 2019, Laura Moldovin and Dr. Lattuga sign a no-fault assignment of benefits.
And that's the standard procedure. It protects the patient. The doctor agrees to take money directly from the insurance company, and crucially, agrees not to chase the patient for any extra money.
So as of September, Dr. Lattuga is locked into the state rates. He's playing by the rules.
Right, until November 5th, 2019.
The day of the surgery.
The exact same day. On the very day Moldovan is scheduled to go under the knife, Dr. Lattuga's office issues a new document. And it says essentially, we hereby revoke the assignment of benefits.
Wait, can you do that? Can you sign a contract saying, I'll take the insurance rate, and then right before the patient gets anesthesia, say, actually, never mind, I want to bill you directly?
The defense argues very strongly that legally, no, you cannot do that unilaterally, especially because the insurance company, E18, was actively paying bills for this patient.
They were sending checks.
Yeah. Yes. They hadn't denied coverage or anything.
So why do it? Why would a doctor just throw away guaranteed insurance money?
It's all about the arbitrage, the difference between the fixed price and the price he wants to charge. The defense motion breaks down the math, and it is. It's startling.
I have the numbers right here. Under the no-fault fee schedule, the code for this surgery, -EPT Plan 22612-, it reimburses at exactly $3,621.12.
So $3,600. That's what the state says a spinal fusion is worth in this context.
But because Dr. Lattuga revoked the insurance assignment, he turned around and sent a private bill to the patient for $45,000.
$45,000. That is a markup of over 10 times the standard rate.
That is the aha moment right there. He swaps a $3,600 reimbursement for a $45,000 invoice.
Correct. And this is the core of what the defense calls the bait and switch. They argue the practice lures patients in with the promise of no-fault coverage. Don't worry, insurance covers it.
Right.
And then, once the patient is committed to the surgery, they switch them to private billing to inflate the costs. Massively.
But hold on, Laura Moldovan is a cyclist. She's likely a regular person, not a millionaire. Does she just have 45 grand sitting around for back surgery? If the insurance isn't paying, who is?
That is the perfect question. And the answer reveals the next layer of this whole financial web. Since the patient can't pay cash and the doctor refuses the insurance rate, well, the patient enters into a complex system of liens and loans.
Liens and loans. It sounds like we've left the hospital and walked into a bank.
Pretty much. Dr. Lattuga requires patients to sign a private assignment and lien. This document gives his practice priority over any settlement money the patient might win.
So he's effectively buying a stake in her court case. I'll operate now, and you pay me my $45,000 when you win your suit against the cab driver.
He's betting on the lawsuit. But he's not just waiting for the money. The source material mentions something about interest.
It does. This is one of the most striking details. In his deposition, Dr. Lattuga admitted that he charges patients interest on these unpaid medical bills while the lawsuit is pending.
A doctor charging interest, like a credit card company.
Exactly like a credit card company. He estimated the rate at 7% per annum. So while the patient is recovering and while the lawyers are fighting for years, the medical debt is actually growing.
The patient's own body has become a financial asset that's generating a 7% return for the doctor.
That feels incredibly predatory. You're hurt, you're vulnerable, and your doctor's charging you vig. But there's another piece here, the third-party funding. Because the defense mentions a check for $15,000. Where did that come from?
This is where it gets really sophisticated. See, even with the lien, the doctor has to wait for the case to settle. He wants cash flow now.
Yeah.
So companies like Law Cash or Absolute Legal Funding, they step in.
Oh, I think I've seen their ads on late-night TV. It's your money, use it now.
Those are the ones. In this scheme, the funding company lends money to the patient, usually at very high interest rates. The patient takes out that loan and immediately hands the cash over to the doctor as a partial payment.
Let me make sure I have this flow straight. The patient takes out a loan for $15,000. They give that cash to the doctor immediately. Now the patient owes the funding company the loan plus interest. And the patient still owes the doctor the remaining $30,000. Plus the doctor's own 7% interest.
You have summarized it perfectly. It is a cascade of debt. And the defense points out what they call double dipping.
What's that?
The records show Dr. Lattuga was still accepting no-fault payments for checkups and smaller things, taking the safe, guaranteed state money, while simultaneously setting up this private funding engine for the big-ticket surgery.
Yeah.
The defense argues this just flat-out violates New York insurance law.
It sounds like the patient is taking on a massive amount of financial risk here. I mean, if they lose the lawsuit, they still owe all this money, don't they?
Technically, yes. They've signed contracts. They're on the hook for tens of thousands of dollars.
So clearly, the defense lawyers are furious. They're writing this letter to the judge because they want to tell the jury all about this. They want to say, look, this doctor is biased because he has a huge financial stake in the outcome.
Right. But there's a legal hurdle. Usually in court, you can't just bring up bad stuff a person did in the past to prove they're a bad person today. It's the rule against propensity evidence.
Right, you can't say he robbed a bank 10 years ago, so he definitely robbed this one.
Exactly. However, there is a famous exception to that rule, Federal Rule of Evidence 404B.
404B, we hear that on legal dramas all the time. What does it actually allow?
It allows you to introduce evidence of prior bad acts if you're using them to prove something very specific. Things like a plan, a motive, an intent, or, in this case, a scheme.
So you're not saying he's a bad guy. You're saying, look at this sophisticated blueprint. He follows the exact same steps every single time.
And this is where the defense brings out the list of names. It's not just Laura Moldovan. They list other patients. Unju Kim Choi, Jae-sun Hwa, Sean Lee, Yumi Choi.
All involved in other lawsuits. And the pattern.
It's identical. Step 1, the patient signs a no-fault assignment. Step 2, surgery is proposed. Step 3, the patient gets third-party funding, usually exactly $15,000 up front.
Okay.
Step 4, the doctor revokes the no-fault assignment. And Step 5, surgery is performed and the massive private bill is generated.
It's a script.
The defense argues it is exactly that, a business model. They claim Dr. Lattuga isn't making medical decisions based on what a patient needs. He's manufacturing high-value medical damages.
By inflating the bill to $45,000, he makes the potential value of the lawsuit that much bigger.
Yes. A bigger lawsuit means a bigger settlement, which means there's enough money to pay off the lien, the funding company, the lawyers, and, of course, the doctor.
And the defense wants to cross-examine him on this. They want to ask, Doctor, did you operate because she needed it or because you needed to feed this financial machine?
Precisely. They argue this unique scheme gives him a massive financial motive to lie about the medical necessity of the surgery. If the surgery doesn't happen, the funding doesn't trigger, and the high-value lien doesn't exist. The surgery is the key that turns the ignition on the whole thing.
There's a human element here that we need to touch on. The defense brings up the background of these patients. Laura Moldovan is a Hungarian national. The other patients they list, Choi, Lee, Hwa, they appear to be from the Asian American community.
The defense explicitly argues this scheme seems to target vulnerable populations. These are often non-native English speakers who may not fully understand the complexities of the U.S. litigation or insurance systems.
So they trust the authority figures, the doctor and the lawyer, to guide them through it.
Right, and it paints a picture of people being, well, herded into a system they don't fully understand. The defense also uses the term outlier. What they mean by that is a statistical argument.
Okay.
They want to tell the jury, look, Mrs. Moldovan isn't just an unlucky patient whose back didn't heal. She is part of a statistical anomaly. They argue that in Dr. Lattuga's practice, an inordinately high number of patients seem to need surgery that then fails to provide them relief.
Basically, if everyone who walks through your door needs a $45,000 fusion, maybe the problem isn't the patient's backs. Maybe it's the doctor's business model.
That is the clear implication. They are framing the patient not as a person who needs healing, but as a unit of production in a billing factory.
Now, to be fair, we have to look at Lattuga's defense. He was deposed. He had to answer questions under oath. What does he say about all this?
In his deposition, Dr. Lattuga admitted to the interest charges and the liens. He didn't really deny the mechanics of it. However, his justification for revoking the insurance is usually that the patient's basic economic loss benefits were exhausted.
Exhausted meaning the insurance money just ran out.
Right. He claims the no-fault money was gone, so he had to switch to private billing just to get paid at all.
Which sounds reasonable on the surface. I mean, insurance limits can be low.
It sounds reasonable until you look at the evidence the defense dug up. They included an affidavit from the insurance company, ADIC. The claims examiner, Cheryl Glaze, states clearly that on the day of the surgery, Moldovan had an active claim and funds available. They were still paying other bills.
So factually, the money ran out excuse was false, at least in this specific case.
According to the insurance company, yes. And even if the money had run out, the state has issued opinions on this. If you start as a no-fault provider, you're generally stuck with those fee schedule rates. You can't just jump from $3,000 to $45,000 because you hit a cap.
So let's just zoom out and look at the big picture here. We have a bicycle accident. we have a disputed surgery, and then beneath the surface, we have this massive struggle over money.
It is a really stark example of the friction between healthcare and litigation. You have a bill that is 10 times the standard rate. You have a doctor charging 7% interest on his own invoices, and a defense firm arguing this whole structure is designed to defraud both the patient and the insurance companies.
And for you, the listener, this matters because we all pay for this. When insurance companies have to settle cases with these hugely inflated medical bills, premiums just go up.
Absolutely. It drives up the cost of auto insurance for everyone. But more disturbingly, it raises the safety issue. If the financial incentive is so heavily weighted toward performing surgery, there is a risk that patients are undergoing these invasive spinal procedures they might not actually need.
That is the terrifying part. Getting a huge bill is one thing. Getting a spinal fusion you didn't need is something else entirely. It leaves you with permanent changes to your body, risks of infection, long recoveries.
And that's why the judge's decision on this motion is so critical. If the jury hears about this alleged scheme, they might look at Dr. Lattuga's testimony very differently. They might see him more as a businessman than a healer.
But if they're barred from hearing it, they might just see a simple disagreement between two doctors.
Right.
It really highlights how much happens in the shadows of a lawsuit. We think of court as being about what happened on the street, but so often the real battle is about what happened in the billing office.
The paper trail is often more revealing than the skid marks on the road.
Well, that brings us to the end of this deep dive into Moldovan v. Singh. We've gone from a door opening on 14th Avenue to a forensic accounting of a medical billing scheme.
It certainly changes how you look at a medical bill, and maybe it makes you want to read the fine print on those clipboards a little more carefully next time.
I want to leave you with this thought. We assume the medical system is designed to heal, and the legal system is designed to find the truth. But when the billing system incentivizes more procedures at higher costs, and the legal system relies on those bills to calculate damages, at what point does the patient stop being a human being in need of care and start becoming a financial asset to be leveraged?
A troubling question indeed.
Thanks for listening. Stay safe out there and watch out for opening doors both on the street and in the fine print.